Hey everyone, this is Rob Ryder, June 5th, 2015, and we're going to talk about driveway robbery. Is that what it is, or is it that your unauthorized accessing of the right-of-way without permit or racing license is the reason that when you get stopped on the side of the road, they give you a ticket for vehicle based on the vehicle code, motor vehicle code? Because basically you're unauthorized to access the right-of-way. And as we'll see, rights of way are private property. And private property, if you don't have a permit, they don't have to let you on it. And it's not your driver's license. It's a driveway permit, of all things. Or so it looks. And so we're going to look at this. I'm not going to spend a lot too. It shouldn't take too long for me to explain the few things I even know about it. But for people that are interested in why you need a driver's license and how do you get away from having one, I think it's as easy as going down and getting a permit for your driveway. So you might want to pay attention. And let's go figure this out, because I really don't know the answer, but I can see what they're doing right here. So let's look at a definition first. Right-of-way is a term used to describe the legal right established by usage or grant to pass along a specific route through grounds or property belonging to another. It's a legal right. So this is like a, something in your imagination. It's really it's personal property, legal right. As opposed to real property, which is, a further definition is a type of easement granted to reserve over the land for transportation purposes. This can be for highway, public, footpath. This is common law right of way. And this is personal property, the one up here, legal right. That's like a personal property right away, where it's an intangible right, not tied to the ground. Or the right of way, in this definition, for an easement granted over the land is, particular land that's been, some of the rights to it have been given up for the common good, but the owner still retains ownership. So highways are on private property because the owner didn't give up ownership of the property, just he gave a right for it to be used. Highways are on private property, and you need a permit or license evidencing your right to access. Not a driver's license, but a driveway permit. Or in Michigan, it's a license to hold a race. And that's what it looks like, so we're going to take a look at it. But if you could, please donate first. PayPal account is my daughter's name. And well, you got my name. Just pause for a second, write it down, and if you can put something in the mail or by email, that'd be wonderful. I think if you don't get any value out of this, I don't know what I can do that ever gives any value to anything. Let's go take a look. Okay, so let's understand the road right-of-way of Ottawa County, Road Commission and Township collaboration. I bet you collaboration probably has some pretty devious definitions if we were to go look at it. It may be almost like an unfair merger of some kind. So all county roads are located on land that is referred to as road right-of-way. The width of the county road right-of-way, now it's the county road right-of-way, not just the road right-of-way, but now it's the county road right-of-way. So the width of the county road right-of-way can vary a great deal. However, the general rule of thumb is that the road right-of-way is 66 feet wide, approximately 3 feet on both sides of the road. You notice we went from road right-of-way to county road right-of-way back to road right-of-way. It's like we're talking about two different things intermixed in the same sentencing, and that just, it's what they do. There are instances where the road center line does not match the center of the road right-of-way. It is advisable to utilize surveying or engineering firm to determine the actual width and location of the road right-of-way. Road right-of-way compared to county road right-of-way or anything else, where is the road right-of-way? The road right-of-way is intended for all county road, pedestrian, facility, and public utility purposes. Okay, so there's a good reason to have it, right? Plats are maps recorded by the state to establish right-of-way and lots within a subdivision. So it's these plat maps, whatever these are, plats are mass recorded by the state to establish right-of-way and lots within a subdivision. Right, that's the description that you want to have associated with your land, not the legal description that they made up. This is back down to the land, a plat map. Again, I don't know that I can prove any of this. It's just my opinion, and, if I'm wrong, well, then it doesn't mean I'm all wrong, just wrong on that one little point. But this is mainly colored for the picture and not the skeleton. But some interesting things about right-of-way use, right? The driving surface, road shoulders, road, and county drainage system. Now, that's the biggie. It's the county drainage system. You got to be able to drain the water, or you're going to have flooding, so you can't interrupt the drainage. And when you get a driveway put in, that's why they have to decide by the drain commissioner if you need to have a culvert or something. Right? So that would take care of that. That's what the county wants. So the county, now you think about it, so you got a road going through some property, and then the county on the side of that has its right-of-way for the drainage system. And so for you to come out of your private property to get onto the right-of-way that, has your land, you need to cross the county's right-of-way. And so you have to have a permit. And that's what you get when you get a driveway permit from the county. But as it turns out, you're supposed to get one from the state also. And anytime you get pulled over on the road for a ticket, right, they're charging with a state offense. It doesn't matter if it's a side road or whatever it is. It's going to be, per some state of whatever vehicle code. So they're all part of the state road highway system, which is part of the interstate system, which makes it all commerce, which means they're involved in antitrust activity if they take your property without just compensation, which is kind of what happens when they pull you over on the side of the road. But we don't want to have to go through all that, and I think the thing you do is you go and you get your proper license or permit, and this will make that problem go away. The Road Commission has established right-of-way widths for planning purposes related to long-term growth and development. Primary roads are planned to be 120 feet in width, local roads to 100 feet in width, to 100 feet to 86 width, depending on traffic volumes. Subdivision streets still have the planned 66 feet width. What's all that mean? It means they could have changed it. Hell, your house could be in the frickin' right-of-way. They changed an act. Some Act 638 of 1925 prohibits the placement of any object except authorized mailbox mountings within the county road right-of-way unless the object is permitted by the Road Commission. And that's why it's important to know, what are they calling the county road right-of-way out of the section of land that's the right-of-way for the road? And do you have the permit that they require? And I believe that you do have that one, because you're not being charged for county crimes, you're being charged for state crimes when you get pulled over, state infractions. Okay, that's just a little bit about why it's important to know about right-of-ways. There's much, much more. So this is a right-of-way map. If you go to this is off Michigan Department of Transportation website. They have the right-of-way maps. Right? We were talking about these plat maps that show right-of-ways, so this must have something to do with a plat. But if you want to see what the right-of-ways are, as far as they're concerned, this is a relatively sparsely populated county in Michigan, and it's what I call the state roads. And it's all the road. Everything in black is part of the right-of-way because they're built on private property. And so it's a private road. It's not a public road. It's a private road. All the landowners together made this road. They donated the land, right? And for you to have access to it, you need to have a permit. But once you have a permit, then all of it's open to you. Right? So they're not showing anything in these townships. That's where all the county roads would be. But that's where all the drainage stuff would come in. So the state has their own, and so does the township. So, if you get caught on a state road, so here's how it goes now. If you get caught on a state road, or let's say you get stopped on any road, and they take your driver's license back to their car to run your license, and they see from the address that you never had the proper permit to be connected to the right-of-way, then there's no way you could be where you are now without breaking the law. Because you say your address says you live at this address, and this address doesn't show in the system that it has the proper state authorized permit for a driveway, and therefore you're violating a state law, and they can enforce more restrictive laws because that's the way they wrote the law. That's how your government treats you. Welcome to America. So here in Michigan, right, here's the act. Here's the act that says you got to do something with your driveway. Driveway, banner, and parades. An act to regulate driveways, banners, events, and parades upon and over highways. To provide for proclamational rules, prescribed requirements, issue permits, and provide for the insurance of those permits. Or provide for the issuance of those permits. Permits. You need a permit. Has an S. So to me it means, the good chances are, because I know what I do now, there's more than one permit. Driveway means a drive, lane, road, or other way providing vehicle access to and from the highway, and the highway is built on a right-of-way, and that right-of-way is all private property, so to and access to a private road from the property adjoining the highway. But does not mean any city or village street or other highway covered by the provisions of this act. They're not driveways. They're also highways. So everything is a highway except for the driveway. There's only one highway. Everything is. Except for the driveway that connects you to the highway. Because you need to cross that frickin' drain commissioner's boundary. And you got to have a certificate or a permit to do so. And as it turns out, the state's got the same one. This is what the state's saying they want. Highway means a state trunk line or a county road. Either or, you got two. Permit, no driveway, blah, blah, blah. Issue is lawful except pursuant to a permit issued in accordance with this act. So if you haven't complied with this act and you're on the road and you're saying that's the address you came from, well, you just broke the law. Nothing in this act shall be construed to prevent the application of of the provisions of any other statute of this state or local ordinance which is more restrictive than this act, nor to preclude any city or village from requiring city or village permits with respect to any street or highway within its corporate limits. Right? So you might have to have one from the city to be on the roads. You may have to have one from the county to be on the road, and you may have to have one from the state to be on the road. But those are really the three levels of government in a state. You've got state, county, and local government. So my point is I don't think there could be more than three. But we can find out. See, now we know what to go ask. Do I need a permit from you to be on the right-of-way? I need a certificate. If I need one, or I need a license, whatever. But at least in the state they say you do, so let's get the ones that we know we need. So it says permits, driveways. Permits for driveways shall be granted in conformity with rules proclamated by a highway authority, which shall be consistent with public safety based upon traffic volumes, drainage requirements, right, there's that drain man again, so the state cares about drainage, and the character of the use of the land adjoining the highway and other requirements in public interest. Rules shall be prescribed reasonable standards for the design, location of driveways, and may require that driveways shall be hard surface. The provisions of this section shall not be deemed to deny reasonable access to a non-limited access highway. No, you just need to have the permit to connect. They don't care that you do. Every lot, apparently, every lot has been granted access to one, to having one driveway. And you need to go get your permit for yours. And as you see, what happened is, or by resolution, the local government can go grab them all, and they can have them, and you're supposed to be held harmless because they have your permit. Which would mean if you get a ticket, go give it to the people that have the permit. Because the ticket you're going to get is because you don't have the piece of paper that says you can be on the highway, and they're going to charge you with a more restrictive vehicle code because it's worth more money. And that's was the whole reason they did it. Go figure. because somebody wants your money. The boards of county road commissioners may adopt or reference the rules in whole and part. So, in other words, you can have this book, and then the county is going to have their own book. And so, a permit shall not be issued unless all requirements of this act and the rules made pursuant to Section 5 are met, which was this one here. A permit may be revoked by a highway authority, issuing it at any time. Okay, so obviously we're not talking about a driver's license. This section does not apply to a permit issued by a city under City Motor Vehicle Racing Act of 1981. I told you we had vehicle racing involved because not everybody has a driveway. What if you don't have a driveway? Well, how do you get access to the road? Well, they just kind of threw it in this act here about city motor vehicle racing. And that if you get that license from the city, it covers all the requirements of this act right here. Existing driveways, they're exempt, except if the use of the land served by the driveway is changed. Right? The use is the beneficial interest, I guess, right? The equitable interest. And that would be if you buy and sell it because somebody else has the legal title. You don't have it. You don't have the title deed. You got a warranty deed. That's just a warranty deed is a purchase contract between the grantor and the grantee. But it's not the deed to the property. It'd be called a title deed or something. That's the thing that the title company has. Going a little further, so authorization of city or village to issue permits with respect to state trunk line highways, right? So this is going to say that the city could give you the state license, but it's not talking about the county. The county is separate. Except as provided in Section 2, the State Transportation Commission, by resolution, may authorize any city or village to issue on behalf of the state the permits required by this act with respect to state trunk line highways within the corporate limits of the city or village, provided the permits are issued pursuant to the act and rules promulgated under this act, subject to the conditions of as the commission may prescribe and subject to acceptance of the authority by government body of the city or village. A lot to say that, you could go to the state to get the license, or by resolution you could be getting it from your city, but it would be the license for the state. Then we got the permit for the state, and we got the permit for the county, and all we need to know then is, well, do I have to get one from you, city? And you'd have all three of them. But now this is, at the very end of a 2-page act, last sentence says, a permit issued by the city under the City Motor Vehicle Racing Act of 1981 shall be considered to be a permit issued for all purposes under this act regarding any highway located within the limits of the city. Forgetting the fact that we're talking about the drainage of the driveway and and this talked about banners putting stuff over the road and so forth, right? Which they had specific laws written. No, you just go and get yourself one for, city motor vehicle racing permit, and you don't need to have a driveway permit to be on the roadway, on the right-of-way. Because the whole idea is you're trying to get a permit to get onto the King's Highway. Because it is the King's Highway. It's a private road. It's the King's. All the kings who donated land, it's, they're the ones who put it up, but they gave you permission if you have a permit. Otherwise, you're a highwayman. You're a robber. What a simple system. All right, so that's what that one said, and, here's the act they're talking about. City Motor Vehicle Racing Act of 1981. Yes, there is such a thing. And you could read through it, and, it tells you what to do, and I'm not going to spend a lot of time on it, but there is one thing I want to cover, because it's relevant to everything else, is the fact that if you go and get this license, a racing event held under this act, and any action taken under Section 6 and 7 shall be considered as being for the public purposes, including promotion of commerce, and tourism, and for the benefit of the citizens of the city and the state. So they can't deny you the license, or they're restricting your ability to participate in commerce, and that's antitrust activity, and the FTC would come and pound a nail in them. Well, that's what I'd be telling them. Right? You're nailing your own coffin, brother, if you're going to commit antitrust activity. And that's what we need to be using. That's my other videos recently been on the FTC and stuff, because they have the power to enforce the FTC Act, and it doesn't allow for antitrust activity. And antitrust activity, when it's not being trusted. It's telling a lie. They're a bunch of liars. They don't do what they say they're going to do. So, right, and what they've done in this case is, if you didn't know you needed to have the state license, and now you don't get it from the state, but you get it from the city, because by resolution they can have a guy that does that, and you don't get it, then you don't have your state. You may have it for the county, but you don't have it for the state, and they're going to get you for violating the state right away. And you're just one piece of paper from having that taken care of. So in Michigan, they wrote a whole book on this thing, or 41 pages on it. Administrative Rules Regulating Driveways, Banners, and Parades, effective 1998, in our 8th reprint. Okay, the administrative rules portion of this reprint include revisions, Part 9, hearings and appeals of the administrative rules as filed in the Secretary of State, November 13th, 1998. So, this is all administrative. It's all by consent, because we're talking about getting on the highway, right? So they've already consented to this. All you need to do is agree, because to have a legal right may have all legal rights have a obligation. And the obligation is to have a permit. And whatever it costs, well, now that was the cost of participating. Because nothing's for free. In the rules, all references to the Michigan Department of State Highways means the Michigan Department of Transportation, and references to the Commission means the Director of the Department of Transportation. So the Director is the Commission. You would think a commission's a group of people, but no, in this case, the Director's the Commission. Right? So he's the one who makes all the decisions, so this is like your administrative review judge. Because we're going to be going to a lower level to try to get something done, to try to get one of these permits, and they're not going to want to do it. And now what do? You take it to the Commission, who's the Director of the Department of Transportation. The department continues to recognize the right of access to state trunk lines other than limited access highways is incidental to ownership of abutting land. Okay. Platted streets and other public highway approaches and crossovers in the highway medians are not covered by these rules. All right, so they just said the public highways aren't covered by these rules. Well, if they're not public, then they must be private. And I have to stop right here before I forget to say it. A brother told me a story, and when he sends it to me, I'll share it again. But this is how simple it is. He had a court case. Something to do with, trying to put up a fence, and the city saying he couldn't do it, and he went to court, and like he said, the Holy Spirit led him to saying, the very first thing he said in court when he got there, led him to say to the judge, or the special magistrate, or whoever the hell the dude is up there on the other side of sitting in the chair, is this a private or public hearing? Is this a private or public hearing? Is this a private or public hearing? And upon saying that, just once, I'm just saying it 3 times because I like to, the magistrate pushed back from the chair, said case dismissed, and walked out the back door. And the clerk, noticing the judge walking out the back door, yelled for the bailiff. And the bailiff, came because he was called, but by that time they could see, they must have realized what happened, because the brother just walked out the door, and the bailiff followed him to the door and let him go. And all it took to get the judge to leave the frickin' bench was to ask if this was a public or private hearing. Because how can he answer that? If he says it's a public hearing, well, he's lying, because they're not using that. There's nothing in here that's lawful, right? He's committing perjury. And I'm sure this stuff is being recorded. And if he says it's a private hearing, well, then it's a false statement that got you there, and they're still committing perjury. His only choice is to say dismissed and head for the door before you say, I don't accept that. I want to prosecute whoever brought me here. Or you could just let him walk out and see if that's the end of it. But right, if what I'm talking about doesn't work out, do remember that, right? If you go to court for anything, it wouldn't hurt, and it makes a lot of sense. First words out of your mouth is this a public or a private hearing? Outstanding. That is the Holy Spirit working. Okay, so there's a few things in here I wanted to show that, like this right here. Here's that resolution. Means a resolution passed by a local governing body authorizing a specific official to apply to the department for an individual permit or for all permits in a blanket resolution wherein the governing body agrees to indemnify and save harmless all persons from claims of every kind arising out of operations authorized by such permits as is issued. In other words, if they go and get your permit for you and you got a ticket on the road and they haven't given you your permit, then you should take your ticket to them, because they agreed to indemnify and save harmless all persons from claims of every kind arising out of operations authorized by such permit as is issued. In other words, because they didn't issue your permit and they're holding it in their hand, then they're responsible for the debt. If you had the permit, you would be responsible for the debt. But you don't have the permit. They had the permit. And so, if you remember, in the other law, it said that the city or the village could do this. And so at the city or the village is a specific official who can apply to the department for your permit, based probably on the fact that you went to the county to get your driveway permit. The city's going to go get the driveway permit. And what city it could be, it's either, because I don't live in a city, I live in a township. They didn't say a township. But my mailing address is a city. So it could be the city where your mailing address pulled a permit. See what I'm saying? So somebody has probably has your copy of the state required permit. And if you got a ticket right now, you take it to the city hall of the city that's in your address and tell them to take care of it, because they needed to indemnify you. So says this resolution. Rule 247-206, right? If they don't follow the rule, well, then they're not following the procedure. And that's what we want to get them for, is them not following the procedure. Forget what you say I did. I'm going to tell you what you haven't done. Good. Okay, what else is there? Processing permits. Permit shall not be issued for a driveway, banner parade, celebration, festival. A lot of this is just, what we already talked about in the Act, but I did want to say this, that enforcement. If a person fails to comply with any provision of a permit or fails to obtain an appropriate permit, the department may halt his activity from which a permit is required until adequate corrections have been made. Right? Halt his activity. In other words, put you in handcuffs and take you away because you haven't met this requirement. Because the city didn't process the paperwork, or you haven't gone and signed for it, or you didn't take your stuff over to the city because they're supposed to indemnify you, or whatever it is. But this is between this particular license is at the state or city level, even though there may be one at the county level. Remember that. Because I know someone was, when are you guys going to go out and get this figured out next week? That's how you get supernatural increase. Hey, this is really good looking. Pretty simple. Somebody, go out and try it. Let's see if we run across an angel somewhere that zips it on through and say, yes, it can be done. Because I think it'll also change the jurisdiction of your address also, because now you will be connected to the right-of-way. Right? There won't be a toll bridge between you and the King's Highway anymore. Driveway design standards. I don't know. We need to go through any of that. No. Pretty much done with this. Good stuff. Here's the act again. Driveways, permit required, local ordinances. So I believe that everybody's state is going to have something similar having to do with how you get from your private land onto the right-of-way, which is where the highway is located. Existing driveways, yeah, we already talked about that. Construction Act, authorized city. Yep, and the city can do it. Or, again, at worst case scenario is you say, well, again, give me a city motor vehicle racing permit. And they say, well, we don't want to give you one. Say, well, that's be antitrust, right? It says so right here in the law. That's how we're going to try to do it in Michigan. And again, I think because I live in a township and it says the city, that they mean the city that's on my driver's license. Because that's apparently my address. Oh, I live 11 miles out of town. I must be in their jurisdiction. Well, then I need to have a racing permit. All right. Here's how you find out in Michigan. They got regional offices and transportation service centers. And any one of these places should be able to tell you if your address has got a permit or not. Should be something you could FOIA and ask. Do it to the county, do it to the city, do it to the state, and find out if you have a driveway permit for your address. Or just make a phone call. Cut to the chase. So we looked at the state stuff. Now this is what the county does, because this is what the county's going to do. The design, location, construction, and operation of material specifications for driveways and other construction within the highway right-of-way shall meet requirements of current Road Commission minimum construction standards, administrative rules regulating driveways that have been adopted, right? So the stuff we just read, that's what this is. The administrative rules regulating driveways, banners, and parades have been adopted by the council, and current Michigan Department of Transportation standards and specifications for construction. So they got more than one set of rules for a road, and the county has part of that. Permits are required for utilizing any portion of county road right-of-ways of any person, partnership, association, corporation, government entity to construct, operate, maintain, remove, blah, blah, blah. And so the county road right-of-way is for the drain commissioner. I believe, because that's who, they get. When you go to the county, from what I've read, I've never done this, but when you go to the county to get a driveway put in, part of it is the drain commissioner deciding if you have to have a culvert or not, so that you don't disturb the right-of-way of the water. And I believe that's probably the one we're getting, and the one we're not getting is a state one to be on the state trunk railroad or state trunk roads. And all the roads are part of the state system because no matter what road you're on, they're charging you with a state crime. A permit does not relieve the applicant from meeting any applicable requirements of law or other public bodies or agencies. Well, there you go, right? This here that you're going to read in this particular book is for the county, and we're not talking about the state or the city. So if they've got something, you need to go talk to them. Any rules or regulations mentioned on the application or permit form and not mentioned in this manual are applicable, right? So read the back of the can. Indemnity and insurance. Permittee shall save harmless the road commission against any claim for damages arising from his negligence or, okay, well, you did that by getting this. And general liability insurance carried by an applicant or contractor will usually be accepted. So this is where I think, a certificate of a general liability insurance policy for $500,000 property damage, $500,000 insurance given to the county and indemnifying them for the future because you're going to get a permit from the state, and that's through the city, and this takes, this is going to take care of the county. That's the insurance they're talking about. All right, so when they pull you over and ask you for your license, they're talking about your license to get on the right of way, for your driveway. And the insurance they're talking about is this insurance, a general liability insurance that either we give, it's going to the county, or need to look closer to see if the state's asking for one. But you get a liability insurance policy for $500,000. You give them both a copy. And that is your auto insurance. You don't need to have auto insurance anymore. Right? You're licensed and bonded. Enforcement. A person fails to comply with any portion of this permit or fails to obtain an appropriate permit. The Road Commission may halt his activity for which permits is required until adequate corrections have been made. Right? They're just taking basically the same words using the last one and saying it applies to the county, except for the parts they want to change for their benefit. Public and private utilities for electric power, cable, television, telephone, telegraph, water, so forth, sewage. Those are affected utilities. Such utilities may involve underground surface overhead facilities. And these are all in the county's, in the right-of-way that the county uses, or they're not in the right-of-way the county uses. They're in your property, which is, again, you gave the county the right-of-way, the use of the land to put in the drain system. But you didn't give them the land, and so these utilities that are on the land, whatever the tax base is for those being there, that's your money. Right? They owe you for running stuff through your property. You don't owe them anything. They owe you for running it through yours. But we don't have the right permit. And it could just be this simple, again, that you're not connected to the right-of-way. And once you are, then you're connected to commerce and you're seen everywhere, and, you're not a highway robber man who doesn't have a permit to be there. But they're not going to say that's why they're giving you this ticket. They're just going to give you a ticket because, they can. I don't know. Did I say on here that, what did it talk about? Oh, do we mention this? Public Acts 368 prohibits the placement of any object except authorized mailbox mountings within the county road right-of-way unless the object is permitted by the Road Commission. And still, your box has to be authorized to be in the right-of-way. And I don't know exactly what that means yet, but it's something that needs to be found out. What authorization is required for the mailbox to be in the right-of-way? Because, here where I live, they're out by the side of the road. And a lot of places where there's, a lot more houses, well, all the mailboxes are, at some mail station that's still, it's built within the right-of-way of the road because it's right next to the road so that the guy can pull up and put the mail in. Well, if none of that's been permitted, then everybody who has a box there has an unauthorized piece of, machinery. Well, not machinery, but a U.S. post box someplace where it shouldn't be, and you're not authorized. So you got to check on your post box, and you got to check on your driveway. And if you don't have either of those, well, then you need to go get a license to have a race because it meets all the requirements. And that's where we're going to leave it. So something to look at, guys. It's it's driveway robbery, or your unauthorized accessing of the right-of-way without permit or racing license. And you've been told. Let's go see what it means. Talk to you. See ya.